A demon is in the corner, in chains of conviction. It can't get away. Anxiety is building. The demon is held at bay. Man's law is so imperfect. In the corner, the demon is bound, praying for the case integrity to be solid, true, and sound. Truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we are once again together, you and I, to discuss post-conviction, post-trial. I wonder how many people, when they watch a trial and they get to the conviction and even get to the sentencing, maybe they even see a few stories afterwards about, they see her walking into the prison, or maybe down the road you might hear that she's doing interviews or something to that effect. But folks, I don't believe that a lot of people take the time to realize that the adjudication of this case goes on long after a conviction. Yes, I'm sure many of y'all understand the whole appeals process, huh? Or how about this latest news where I got all kinds of comments about what's going on, what's happening? She's asking him for a new trial. Oh, this is terrible. She's going to get away. Folks, tonight we are going to go over some things. We're going to analyze a few things. We're going to get a few things post-conviction and post-trial squared away. Because you see, it isn't just about going all this time, over 2 years, studying this case, researching and analyzing it. It's about taking it and realizing that you have to look back on it. Because, folks, there's going to come a time that an appeals court is going to overlook the whole case. They're going to look it over, and they're going to see what Judge Boyce has done. So we are in post-conviction, and we are, post-trial. What is post-trial? I think, some of y'all are going to be educated if you'll take the time to listen. Because I want you to know, I didn't know this information myself. I had to search it out and apply it to this case. A post-trial is a formal inquiry designed to prove and put upon the record the blameless characters of the judges, the advocates, and the jurors. And so when we think about that, we think, okay, there's got to be a way for Judge Boyce to be, checked on his work administratively. He ruled from the bench. And folks, let me tell you, we do have a conviction on that damn Hussy. And we have a sentencing, July the 31st. And we're going to go over a little bit about that as well. I want to share a few things about that. Because in the last live stream that I did, we all tried to, kind of get into this mindset of what, an impact statement would be. But I think that there are some interesting facts that would be excellent for you to be able to take in and say, you know what? I studied this case. I put the pieces, everything that even seemed irrelevant. It brought more enlightenment. It brought, you take everything and you can't leave out post-conviction. But adjudication doesn't end at this. How solid is the case in chief that we got a conviction on? Larry Wilcox said, and Kay agreed, and I'm sure Kresha and other victims' family members agree that this was a righteous verdict from these jurors. They did the best they could. We'll go over that as well, because Lori's attorney wants to shake shake the chain, jerk the chain of one of these jurors, and I'm sure you know what I'm talking about. How about the integrity of this case? We all bellyached, or at least I'll just speak for myself. I bellyached about severance. I bellyached about the death penalty being taken off the table. And I bellyached about other things, and we'll go into that too. We got a motion for a new trial, which is not an appeal. It's just something that has to, that Archie has to do, and I can leave it at that. But again, I want to share what I've learned. And then, of course, after the sentencing, when she's sentenced, y'all, you got state and federal appeals. And I'll briefly go over that. Because, folks, listen, if we're going to if I'm going to get my panties in a wad every time I hear something that her attorneys are trying to do to get her ass out of prison, it would disrupt my life. And the bottom line is this: she ain't going nowhere. She ain't going nowhere but the freaking chow hall and the freaking shower using that damn generic yeast infection medicine. That's what she's going to do for the rest of her days. The administrative duties of Judge Boyce. Is he tying up the loose ends? I see evidence of it now. There are certain judicial procedures that have to take place in order for this to continue to move forward in post-conviction. Will Judge Boyce's rulings from the bench stand the test of time? We're going to find out. And I've got several things I want to talk to y'all about tonight. And I'm going to do my damnedest to make it as easy to absorb, because I'm going to tell you what, there is a long, long way to go. Everyone's looking toward Arizona right now. And rightly so, because if anything goes wrong in any of this, you got the backstop. That's what I've always said. The backstop of Arizona that's going to handle this damn hussy. She wants to crawl out of that corner. She's going to have a hard damn time doing it. Hello, Philly. Hello, Cosette. Hi, Mark McGarry. CHP. Hey, listen, Mark says, KJ reminds me to check out the process. We have to, y'all. If we truly are interested in getting justice through understanding, and also being able to have some assurance that the victim's family members are getting the justice they deserve, folks, every damn time this damn hussy files an appeal, it's probably gonna knock these victims' family members off base for a little bit. But all I can say is that I have peace of mind knowing that, again, I feel like this case was adjudicated properly. Hi, Just Me. Hi, Louisa Uva. Let's see who else. Jill Schneider. So anyway, these are some things that I'm going to have to go into it, because if I don't, we'll be on here for a very long time. And I want to be able to, I guess, shake things up a little bit for people to understand that post-conviction, it goes further than that. And a lot of people don't take the time unless they see a news line down the road. Oh, they're trying to appeal their conviction. I mean, you got Cresha K. Easton of Difficult Research. She's posted something on this Pizzuto guy who's on death row, and how this Robin Rowe, I mean, she's still got all her appeals going on, but folks, Lori didn't get the death penalty. So she's down a different line of track. And by the way, wasn't it last year, maybe a year and a half ago, the state was talking about we don't need inconsistent verdicts. What about Chad Daybell? We'll talk about that too. So I'm going to go ahead and I'm going to just start going through this. I tried to put this together as best as I knew how to basically let y'all know that these are the things that I am looking at, a bit concerned about, and things that I'm at ease about, okay? I'll leave it up to you on whether you want to take this information and move it forward in your own research, or whether or not you're just going to let it go. Because some people are going to just let it go and they're not going to deal with it until the next headline. Again, we've got the sentencing coming up, so that's the next, I guess, the big news. But anyway, I just want y'all, hello, Suzanne. I just want y'all to know that this is important. Hello, Jennifer Esslinger. Okay, so I want to start off, and I'm going to only talk briefly about this because I think y'all need to understand that this comes from a different vein of what we're talking about post-conviction, okay? Before the court, all right, this is a legal document here. It was filed just yesterday. Before the court is a non-party movement, Lori Hellis. It's post-trial motion of non-party movement to unseal all documents and transcripts or recordings of past hearings related to this matter with necessary redactions hearing requested. So this Hellis woman, she's back at it again. This is post motion that she's filed. She wants all this stuff released, okay? And as many of y'all recall, and I'll just recap it, as this case was being adjudicated before Lori went to trial, she inserted herself in this, and everyone's got a wide-ranging opinion on her motives and all this and that. But I just want to touch on the things that I find important in this motion of Lori Hellis. Before I say that, though, the judge has ordered that any and all exhibits in Lori's trial have to be kept under seal now. That is another legal document that has come out. Basically, it comes down to the same exhibits and such for Chad Daybell. So that makes sense. It makes all the sense in the world, y'all, because Chad Daybell is facing a trial. He has ordered that all exhibits be sealed, okay, so that nobody can look at them, so there can't be any issues. But going through this, Judge Boyce has basically said Hellis has filed a memorandum in support of her motion. For the reasons following, the court will deny the motion without a hearing. So Judge Boyce is telling Lori Hellis, I'm denying your motion to get these things released, and on top of it all, you're not going to get a hearing in it, okay? And he goes into the facts and the proceedings of it. I'm not going to go into that, but I do want to draw y'all's attention to his notes in this. He absolutely goes through case law and everything, but he talks about to schedule any court hearing or proceeding, counsel must contact the clerk of the presiding judge to arrange a time certain. Hellis does not hold an Idaho State bar license. The court also notes that despite Hellis's continued self-described characterization as a member of the media, an author, and attorney, which titles are presumably included in all of Hellis's pleadings as an attempt to bolster her credibility, she is the only individual that was ordered removed from the courtroom during the trial in this case based on conduct that violated the court's conduct order in effect during the trial. The determinations made herein are thus made without consideration of those titles. So the judge is saying because she's given herself these titles, he's letting in his notes for judicial review that he's not even looking at that, really. But then the reason he talks about not giving her a hearing to get all this, first of all, he's not going to let her have anything, and then he's not going to give her a hearing. Among the errors in her filings, Hellis refers to Exhibit 1 in her motion, but no exhibits were filed with the court. Number 2, Hellis cites 2 rules of civil procedure and family law procedure as authority, neither of which apply to criminal cases. And 3, the certificate of service lists a date of August 25th of 2022 as the date of service. That is patently incorrect. Number 4, Hellis includes John Pryor on the certificate of service, who is not counsel to any party in this case, talking about Lori Daybell's case, and is not appropriate to include on the certificate of service 5, inaccurate email addresses for several of the attorneys that would make meaningless the notice and requirements and frustrate the due process. Hellis has the responsibility to comply with the rules and only include appropriate contacts and to use their appropriate email registered for service through the Idaho State Bar. Hellis refers to an exhibit in her motion that was not attached to the filings presented by Hellis to the court and therefore has not been considered by this court in reaching this decision. The court also found that several of the enumerated documents Hellis alleged were sealed in error in her earlier motion. In fact, were never sealed and has always been publicly available to any individual by physically appearing at the courthouse kiosks. And finally, furthermore, the court emphasizes the express language of Idaho Criminal Administrative Rule 32A that establishes the policies Idaho courts are to consider when matters regarding access to court records come before the courts. The rule is meant to direct courts to provide access in a manner that makes the most effective use of court and clerk staff and avoids unduly burdening the ongoing business of the judiciary, continuing to entertain Hellis's efforts to cast aspirations on the court, interferes with the effective use of court and clerk of court staff, and burdens the ongoing business of the judiciary by taking attention off of many other cases that deserve the time of the court. Now, what am I saying? I'm saying that since this original thing that happened where she got her 5 minutes there in front of the court, what was it, a year ago, she originally talked about something was nefarious going on, something was wrong with the judge, something was going on in the court, county clerk's office, and all this. Now, at post-trial, she wants this stuff released, and he's saying that this is, he just goes down a laundry list of everything she didn't do right. Now, what does that mean? He says without prejudice. That means she can look at this, educate herself, and she can refile this. She could absolutely do that. He sat there just as he did when he responded to her the last time saying, if you want a hearing, you got to do this, this, this. He's telling her now she should do this, 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 and this. And so she will. And so really, I looked at it in terms of, okay, what could this mean? This is part of the record of Lori's case file. Could any of this be brought to the attention of an appellate court, state or federal? Could because she shaded this whole process, and she did. She sure did. This is an opinion. She said quite clearly in her past filings that something nefarious was going on. She made sure to let the Supreme Court, remember that judge she wrote to, Dear Supreme Court Judge? That is part of the record. So there you have one little prong of something that a defense team, not to mention Chad Daybell's defense team, can look at in terms of appellate issues. Would it fly? Probably not. Maybe an appellate court would look at it and say, well, Judge Boyce did tell her how to do this properly, and she didn't do it properly. And if she doesn't refile it, the bottom line is he's done everything he was supposed to do. Now, this whole argument that all this stuff was sealed and it wasn't transparent and all this and that, we've got a mixed bag on that. Some people think everything should have been transparent, but folks, throughout the whole response from Judge Boyce here, he makes it very clear that he already went back after she got heard in court, and he unredacted some things, but a lot of it was personal information and things that would have gone against what? A fair trial. and he has discretion to do this. So I don't see per se that this would be an issue, although it might be brought up. It wouldn't benefit Lori or Chad, I don't believe, in the long run. But it's just sad, is it not, that that is out there. Jill Schneider says she thought she threw shade. She shaded Boyce when she had no proof and now wants Boyce to appease her. Mighty hubris of her, says Jill Schneider. Now, again, there are a lot of people that have come onto this channel before Lori's trial that were new here. And I got the distinct feeling through the comments that a lot of them were on Lori Hellis's side. And this isn't about being on one side or the other. This is about OKJ looking at this. This is post-trial, right? And she's already started this stuff up again. And he's denied her a hearing and all that. But he has, again, given her, I guess, an education on how she can do this. He said no prejudice to it. So she could refile all this and educate herself. We'll just see how it turns out. If, in fact, she does get another hearing after she corrects all of the mistakes that she has made, then everyone will remember on here that OKJ brought it up. But now let's move forward. Oh, and by the way, let me just leave you with this. This would seem like big news, right? Do you know of any news organization out there? One, just one, that's reporting on this? No, you're not going to. I know why, and everyone else should know why too. But anyway, it didn't work last time. She won't learn, says Tina Reddington. Well, she's got to write a book. She wants as much information as she possibly can get. And she got to insert herself in this trial. She's on audio in the middle of one of these motion hearings. In this high-profile case, she'll always be on the record. So at least she got that out of it. Just Me says, I have nothing against her. She just is unaware of what she needs. Hello, Sugar Magnolia. So anyway, so we're going to go on from there. And just remember, y'all, there has not been any other news organization out there that has filed anything like this at all after this case post-conviction. So no other media organizations have done this. Only her. Just keep that in mind. Yeah, right. Judge Boyce wants to be in the book, says Bullseye. And Jill Schneider says she just wants to sell books. And that's her right. Hey, I mean, if she wants to write a book about it, and she is invested in this case. I know she bought a website with the names of Lori Vallow or whatever. More power to her. Let her do whatever she's going to do. Now, there is a difference between a motion for a new trial and an appeal. And most of y'all know this, but I'm just trying to lay this out here in case someone doesn't know this. And we had gotten a lot of comments right when this news came out. And I wanted to be able to go over this with you to just, because I'm sure a lot of y'all have read this anyway, but this is my take on it. And I want to kind of zero in on the view of why they want this motion of a new trial. Let's just be clear. They've got to have, within 14 days, this has to be filed. So it was coming. It would be negligent of Archie and Thomas not to file this. And they have BS reasons as far as I'm concerned. But they've got to put something. So let's read it. Comes now the defendant through her attorney and pursuant to Rule 34 Idaho Criminal Rules moves this court for a new trial. And just to let y'all know, that rule has an A, B, and C section. Now listen to me. Just If you'll bear with me, you'll understand where I'm going with this. In general, on the defendant's motion, the court may vacate any judgment and grant a new trial of any ground permitted by statute. If the case was tried without a jury, the court may take additional testimony and enter a new judgment. Now, I'm going to skip one, and I'm going to go to another one, and then I'm going to go back to the other one because I have something I want to talk to y'all about. Okay, there are grounds for a new trial. Any motion for a new trial grounded on any reason other than newly discovered evidence must be filed within 14 days after the verdict, finding of guilty, or imposition of sentence, or within any further time the court may set during this 14-day span. What is that saying? Any other grounds besides new evidence. And that's what we got in here. That's what we got. There ain't nothing in this motion for a new trial that says there's any new evidence at all. And the reasons that Archie says is the statute which the rule refers to, which provides that the court may grant a new trial in the following cases only when the jury has received any evidence out of court other than the resulting from a view of the premise, and that's not something we're concerned with. When the court has misdirected the jury in a matter of law or has erred in the decision of any question of law arising during the course of the trial, and finally, when the verdict is contrary to law or evidence. And so, just to let y'all know, Archie is saying that the court misdirected the jury in a matter of law as it related to the jury instructions on conspiracy. And this is interesting because he says in this that for the past 2 years, the defense has been put on notice that the conspiracy involved at least 5 people. Remember, known and unknown? But when Archie's saying that they were put on notice that there were 5 co-conspirators, and I'll tell you something right now, I believe that if this was the case, that we're looking at Melanie Pulaski and Zulema. I would like to say Melanie Gibb, but if I had to really look at it and look at who was really where for most of the time, or it could be Audrey Barterio, but at least 2 more. I would say for sure Melanie Pulaski, and then maybe Audrey Barterio or Zulema. And I would like to say Melanie Gibb, but you see more of Zulema and Melanie P. with Lori and around them more than Melanie Gibb. This notice was clear from the language of the indictment to have the government and the court permit a conspiracy of just 2 people instead of 5 was prejudicial and unlawful and should require a new trial. And if you think about it, if they would have been able to, if the state would have brought in other co-conspirators of at least 5, that's 3, that's Alex, Lori, and Chad, and then 2 others, then the defense would have had more of a strategy, not just throwing Chad under the bus or Alex under the bus, but it would have been others. So nothing was ever said other than known and unknown. And the state was very careful about that. Another reason, the court misdirected the jury in a matter of law as it related to the amended indictment. And this is a war of words. It talked about when the state asked, remember when they were saying we have a clerical error, and the bottom line is it was really either intent to deprive or intent to deceive. And I don't believe that one's going to float. I think that the bottom line is that Judge Boyce looked at this, was able to make a ruling from the bench from it, and I just think it's a war of words. It really has not much more meaning. Finally, this latest news of the motion for a new trial, one of the reasons, and this is an attack on one of the jurors, right? A juror interviewed revealed that the jury instructions were confusing and that he knew of evidence not submitted to the jury. And we all know that Nate Eaton went back and he interviewed this Saul Hernandez, and Saul Hernandez made very clear in his interview that he had watched this body cam footage of Charles Vallows 2 days after conviction on a Sunday evening, that he was just referring back to it, that he didn't know this beforehand. And that this whole idea of the 404B stuff, that is something that I don't think is going to be an issue either, because although it is in South Carolina, Alex Murdaugh's trial, they went right into 404B in there about all his financial crimes as showing what? Motive. And that's exactly what it was. It was motive. That's what and Saul Hernandez did say that he was very, very clear in his understanding of what? The jury instructions. So there you go. You've got some outside party wanting to come in here again and say what they're going to say about unsealing stuff. The judge rules on that. Then you have this motion for a new trial that has to be filed within 14 days. And those reasons were given. I don't believe any of them are really good reasons. But let's get back. Let's get back to this that I was looking at in terms of the Idaho Criminal Rule 32. And that is this whole idea of this motion of a new trial having to do with newly discovered evidence. And I don't know if this rings a bell with y'all, but do y'all remember? This is what bothers me. This is what concerns me. And it might just be out of my own ignorance. It could be out of anxiety, paranoia, but this bothers me. And I want to discuss this with you because I'm not 100% clear. And I'm hoping that on the rewatch that one of y'all, some of y'all could maybe talk to me about this. But remember back in April of 2021, Rob Wood originally wanted consumptive DNA performed. But Chad and Lori's attorneys objected to this. Lori's case was then put on hold when she was placed in the custody of the Idaho Department of Health and Welfare. Now you move forward a year. Remember, Rob Wood and them came back a year later and said, well, we put it off because she'd been ruled incompetent, and we knew that it would be better for us to do this while, when she was able to help in her defense. But about a year later, July 2022, in a motion filed by prosecuting attorney Lindsay Blake and Rob Wood, they asked Stephen Boyce to allow them to test the following items. Now, just bear with me, because we know what DNA was brought out during Lori's trial. We also know the reason this case got severed. These are the items, y'all. Hairs, more than one, on duct tape inside a body bag used to transport the remains of JJ. And we know during Lori's trial, there was a hair, okay? But this right here is talking about hairs, plural. So there's more than one hair. But remember, this was stuff that they already had in April of 2021. They're waiting a whole year. They're coming back. And these are another thing. The ridge detail, fingerprints on the adhesive side of duct tape associated with JJ Vallows' body. Now we know in Lori's trial, what did we find out? There was a palm print, not on adhesive tape. It was on the outside of the black garbage bag. So here we have at least some other hairs are hanging around out here because only one's accounted for. Also, we don't know anything about this. The fingerprints on the adhesive side, and we're not talking about they're matching up the fingerprint on the adhesive side. They can swab that for DNA, okay? Another thing, small dark spots on the handles of a shovel and a pickaxe recovered from the garage and barn. We know this was at Lori's trial, y'all. We know at the eye of the pickaxe and on the handle, there was Tylee's DNA, okay? So that was accounted for. Swabs of tape areas. That's another thing. We didn't hear anything else in Lori's trial about this. And the reason I'm bringing this to your attention is because this is why the case has been several. Something in here was turned, these right here were not turned in late. You see what I'm saying? These were not turned in late. There's got to be something else. Swabs from fingernails from JJ's right hand obtained during his autopsy. Did y'all hear anything in Lori's trial about this at all? But we know that Chad Daybell, through his attorney, John Pryor, filed its latest motion to split the case based on new DNA evidence that had been recently made available to all the parties in the case. And y'all remember, that was February, March of this year, before the cases got severed. So what I'm speaking of before this, all these things that we're talking about, had already been in the possession of the state since 2021. But now they're saying there's new DNA evidence. So it says here, John Pryor, of course, argued Thursday that he needed at least 60 days to get testing done on a new DNA report, which was received in a hearing earlier this week. This is during end of February, beginning of March, y'all. Pryor called it a piece of information that will have a profound impact on this case. Okay, now let's stop for a minute. If this piece of evidence that got these cases severed was hair, it couldn't have been Lori's, the report showing it was Lori's hair on the duct tape, because why would John Pryor want to test it? That would actually, I mean, he wouldn't have to, he'd be like, oh, that's Lori's hair. I don't need to test that. That shows that it wasn't my client's hair, right? There were short hairs, y'all. Was it Alex's? Was it Chad's? So why would Pryor want to test a hair known to be Lori's? Why would he want that? Obviously, if you want to look at it common sense, he probably would, even if it had been Lori's hair, and the report said this is Lori's hair, and the state used it during this trial to say that hair, that was Lori's hair on that duct tape, right? The bottom line is he was trying anything and everything to get out of going to trial, and he definitely wanted this case severed, but I just don't believe that the judge would have been like, oh yeah, that hair in the report says it's Lori's, and you're saying that this is crucial. The judge would have been able to see that this would have been more beneficial for Chad had that been in the report that it was Lori's hair, okay? And so it would have to be what? It would have to be Alex's in the report. It shows that it's Alex's hair, or it had to be Chad's. And of course, you know John Pryor would want to test it if it was Chad's, y'all, because he would hope that his DNA expert could find inconclusive or anything, because that's damning shit. Okay, so it would mean something to me if it was Chad's. If it had been Alex's, I mean, it wouldn't have been no different if it would have been Lori's, because if it had been Lori's or Alex's, that would have been beneficial for Chad, because it would have meant it wasn't Chad's. Does that make sense? So let me get back to this whole issue. Newly discovered evidence, which is Idaho Criminal Rule 34, Section B. Any motion for a new trial grounded on newly discovered evidence must be filed within what? 2 years, y'all. And the reason I bring this up to you is because Lori has 2 years. When they get this result back from this DNA, if it shows that it's Alex or Chad's and not Lori's, do you think that Archie's not going to file a motion for a new trial because he has 2 years to say, hey, this is new evidence. This is new evidence. If an appeal is pending, the court may not grant a motion for a new trial until the appellate court remands the case. So in this 2-year period, if an appeal is not given, and do y'all think it's going to take 2 years? No, it's not going to take 2 years to get that report back. John Pryor said it'd take only 60 days. So Archie has a window in there before appeals kick in where he can say, oh, this is new evidence. If it's not Lori's hair, y'all, it's new evidence. And she could possibly get this is what bothers me. Now, of course, an appellate court, if down the road, say this was there was an appeal in progress, and they wanted to say, look, this is new evidence, and this might reverse the conviction. Not give a new trial, but reverse the conviction. They'll look, the appeals court will look and see where Archie said in a hearing. He said, we feel like, we need more time for this. As John Pryor's over here saying, this is crucial new evidence, and this is a reason to sever the cases. And I've told my client that this is important, but she wanted what? She wanted a new trial. She wanted a speedy trial. Excuse me. That's what she wanted. So that will be on record. It will all depend, y'all, on what the appellate court thinks. It won't be because Archie couldn't force Lori not to have her speedy trial. He did what she wanted him to do. And he put on record in that hearing when they were arguing and motioning about severing it because of the late DNA that was turned in by the state. He did say on record that she wanted her speedy trial. And because he had advised her that, hey, this could be important and we need more time, she wasn't going to budge. She wanted her speedy trial, and here you go. But again, it's going to be out there, y'all. And it's something that concerns me more than anything else. Patty and Pink says the hair on the duct tape DNA was Lori's. And yes, Patty and Pink, in the trial, there was one hair. But in the items that the state wanted back in April of 2021 to do DNA testing on, and then they had to wait because Lori was ruled incompetent, the bottom line is they say hairs, not one hair. And the question really is what is this DNA evidence that was turned over at the last minute by the state? And could this help Lori? She has 2 years to get a new trial. She has an appeals process where she can add that in there. So again, just remember, y'all, that these things are out here. They will be visited. And, I'm just being realistic about it. Now, another order that was filed yesterday was this order. The court has previously requested both orally from the bench and in written order that the state file with the clerk of the court a written form as required under Idaho Code Section 19-5306, Section 2, to establish who qualifies for the protections enshrined in the Idaho Crime Victims Act. In order for any qualified individual to provide victim impact statements in writing to the court or orally at sentencing, any such individuals must provide a statutory required form prior to sentencing, and none has been turned in yet. The prosecuting office should have been given these forms to Kay, Larry, Summer Shipley, Kobe Ryan, whoever else that is going to be doing victim impact statements. And to back this up, upon the filing of a criminal complaint or juvenile petition, the prosecuting attorney shall inform the victims of the various opportunities provided by this section, and the section is compensation of victims of crimes. This is Section 2. The victims may exercise any of the rights provided by this section by completing a written request on a form provided by the prosecuting attorney to the clerk of the district court. The clerk thereafter shall notify the appropriate authorities of the victim's request. Notice thereafter shall be given to the victim at the address provided unless the victim subsequently provides a different address. And what I'm trying to say is I don't know whether the victim's family members have received these forms from the prosecutors yet. But they have to be turned in before they can do victim impact statements. This is Idaho Criminal Procedure, Administrative Procedure. They've got to be turned over. And so I'm hoping that these the prosecutor's office has gotten this process in gear. Again, Judge Boyce makes it very clear that to date, no forms have been filed with the court, and it is June 1st, yesterday, that he is saying this. So they need to have this. I don't know what's in this form. I tried to Google it and try to figure out what was in the form, but I couldn't get a hold of it. Also, along with the compensation of victims of crimes, Title 19 Criminal Procedure Chapter 53, you got the pre-sentence report. And as many of y'all remember, the last time we were together, I said that I hoped that the victims' family members know that they have the right to read these pre-sentence reports of Lori. Consulted by the pre-sentence investigator during the preparation of the pre-sentence report, and have included that report a statement of the impact which the defendant's criminal conduct had upon the victims, and shall be allowed to be read prior to the sentencing hearing. The pre-sentence report relating to the crime, the victim shall maintain the confidentiality of the pre-sentence report and shall not disclose its contents to any person except statements made by the victim to the prosecuting attorney or the court. So in other words, what I'm trying to say is the victim's family members, they have to turn over these forms. I don't know if those forms include what they're going to have to write down, and whether or not Idaho's got to edit that and say that's okay to read in front of everybody, or whether it's just a form that has their information on it. And also, the victim's family members can read the pre-sentence report of Lori, but they can't talk to the media about it. They don't get a copy of it. And I think it's chocked full of information and answers a lot of questions about the Hussy. And how do I know? Because I've looked up what is in these pre-sentence reports. And I'm sure a lot of y'all would probably know the answer to some of this stuff that's going to be put in here. We're going to find out exactly what is in this pre-sentence report. Let me get to it, y'all. Here we go. All right. The description of the situation surrounding the criminal activity with which the defendant has been charged is in a pre-sentence investigation report, and it includes, y'all, the defendant's version of the criminal act. And I guess the question is did Lori talk to the people at the Idaho Department of Health and Welfare about her version of events? Or did she ever talk to anybody? Because, listen, y'all, the pre-sentence report has to be done during all this time. They're going to go to her, and it has already been put on the record with Nate Eaton and Justin Lum that she can refuse. These pre-sentence investigators, she can refuse to answer any and all their questions, but it will be put in the pre-sentence report that she didn't want to cooperate, that she had no comment or anything like that. So the bottom line is will she, now that she's convicted, will she give her version of events? And we know that if she does, and she sits down and explains it to the pre-sentence investigator, that these victims' family members are going to have to read her bullshit. Because you know and I know she's not going to tell the truth. She's never going to confess to her evilness. It also includes the defendant's explanation for the act, the arresting officer's version or report of the offense, and the victim's version where relevant to the sentencing decision. The trial judge may, but is not required to order a pre-sentence investigation, and Judge Boyce did this, a full pre-sentence report. It'll have any prior criminal record of the defendant, and of course it's going to be put in the pre-sentence report. Her contempt of court charges back when she was in trouble with Joe Ryan and all of that, the defendant's social history, including family relationships, marital status, age, interest, and activities, the defendant's educational background. And I don't think that Lori's ever been past high school. So, that'll be something that will be brought out. The defendant's employment background. She was a hairdresser at one time. I don't think she's ever worked for an employer, but maybe I'm wrong. I don't think she ever did have an employer. Or when she was a hairdresser, maybe she had an employer where she went and did hair. That's the only thing I can think. Defendant's present employment status and capabilities. Well, we know she hasn't worked a job in a very long time. Her capabilities, I would say Lori would be a really good street hooker. I think she could stand on a corner and they can fling nickels at it. And I think she'd do really good at being a prostitute. The residence history of the defendant. Well, we know she was like a damn gypsy going from from California to Arizona to Hawaii, back to Arizona, then she goes back to Hawaii, then back to Arizona. She's lived in Texas, back to Arizona, then to Rexburg, back to Hawaii again. The woman never really had a real long history of staying in one place. The financial status of the defendant. Well, I don't think Lori's got two pennies to rub together, although if you want to include in that pre-sentence report that Summy or Janice has put a little money on her, on her little books there at the jail, I don't see that the woman's got any money saved anywhere. Although, I've noticed this throughout all of this, that they're good at hiding money. I mean, they're good at hiding money. They're good at stealing money. So we'll just have to wait and see. Well, we can't wait and see. We're never going to know. But common sense says the woman's didn't have any money. The health of the defendant. And I'll tell you this. Nobody's going to tell me that this woman has no health issues at all. She's got to have some health issues. She's 50 years old. She's not she can't be sitting in a jail cell, nearly 3 years. She's got to have some kind of health issues. We know when she was in Hawaii, April Raymond said that Lori had used a friend of theirs, her name, used her friend's name to go to a fast-paced clinic. What was she doing there? I don't know. Maybe she was going to get birth control pills. I don't know. Maybe she had chlamydia. I don't know. Maybe a STD. I don't know. The defendant's sense of values and outlook on life in general. Well, I guess if a pre-sentence investigator sits down with Lori and says, "Hey, Lori, give me a sense of your values and the outlook of your life in general." I would say that Lori's outlook on life in general, I don't see how her outlook could be all that good, knowing she's going to pretty much be spending the rest of her days in jail. Which, by the way, in terms of appeals, on a motion for a new trial, and on the state level, Judge Boyce has to look at his own work on motion for a new trial and rule on it. And you think he's going to go against it and say, "Oh, I made a mistake. Yes, Lori, you get a new trial." I doubt it. It ain't going to happen. The results of any substance abuse evaluation, mental health evaluation. This is going to be very important because this will be included in the pre-sentence investigation. Everything, every note that's ever been taken while Lori was malingering, in my view, in the Idaho Department of Health and Welfare, things she was saying, the mental health issues that she was diagnosed with, what Archie says that she had a variety of them. I think the victim's family members should get to read that sentencing report to know what this woman is supposedly have or whatever, And also domestic assault and battery evaluation. And y'all remember, back when Archie was talking about taking the death penalty off the table, he brought up about domestic violence. And remember how I was like, what the hell is this all about? Oh, I'm sure, y'all. I'm sure Lori's going to fill their head full of shit about how Joseph Ryan and maybe her other husbands, along with Charles, and maybe even go so far as to say Chad was committed domestic violence on me because he had me so fooled, you know. It was verbal abuse. It was manipulation. He did me so bad. The bottom line is, as Archie brings it up in his some of his legal documents, the terms domestic violence. I can assure you, I will never know what's in those pre-sentence reports, but I guarantee you, Lori plays the victim. Lori's going to play the victim. She's going to blame anything and everybody. She's had a terrible childhood. She had domestic violence on her. She had, what is it next? A psychosexual evaluation. Well, I'll tell you what, they're going to have to give her one of those, and I've looked at that. And the woman has had a lot of men between them legs. She was very promiscuous, and she had sex with a lot of men. And it don't matter to me if she was married to them or not. The bottom line is the woman's loose, and she uses sex as a weapon. She uses it as a way to get her way, and that will come out in a psychosexual evaluation. The pre-sentence investigators will give an analysis on the defendant's condition. The analysis of the defendant's condition contained in the pre-sentence report should include a complete summary of the pre-sentence investigator's view of the psychological factors surrounding the commission of the crime or regarding the defendants individually which the investigator discovers. So this pre-sentence report is going to have a report in it. It's going to talk about, okay, her psyche and her mental whatever. We're going to apply this to what happened in this case, where she turned into an evil, diabolical murderer of her children and helped conspire to murder Tammy. And obviously, they're going to try to put in the pre-sentence report a plan, y'all. A plan to rehabilitate the Hussy. And I can tell you right now, hey, folks, I believe in rehabilitation. I believe people deserve a chance after anything they do. But this woman is too far gone, in my opinion. She's evil. She'll never come to terms. You've got to come to terms with what you've done in order to heal from it, to get rehabilitated. And unless she sits down with this pre-sentence investigator and says, I see where I went wrong. I did what I did. I can't change it. I wish I wouldn't have done it. Even if she's blowing hot air, the bottom line is if she doesn't cooperate or if she doesn't show any signs of remorse, I'm telling you, y'all, there is no rehabilitation for evil. There is no rehabilitation for someone who doesn't want to come to terms with the murderous spirit. I guarantee you, this pre-sentence report, I wish more than anything that I could read it. But I'm not going to be able to. It would answer so much. Especially if it says in the pre-sentence report on page 7 or 9 or whatever, a whole blank sheet saying she refused to talk to us. That right there would just absolutely just be like, yep, that's exactly what I expect from her. For her to not say anything and not cooperate in a pre-sentence investigation tells the judge everything, tells the person giving the investigation everything they need to know. The woman has no remorse, y'all. She has no remorse. She's never going to have any remorse. And by the way, as I read this, there's going to come a time that Chad Daybell's going to get convicted, and this applies to his ass as well. And I'm going to tell you what, that sling blade, nasty ass asshole, he's liable to spin a tail. Mr. I can tell stories. The pre-sentence report may, however, recommend programs or treatment for the defendant, and it can comment to the length of time that may be required for the defendant to complete any recommended programs or treatment. The pre-sentence report may also comment generally on the probability of the defendant successfully completing the term of probation or the defendant's financial ability to pay a fine imposed by the court. And y'all know there isn't going to be probation and there's not going to be any fine imposed, although I will say this, I would sue the shit out of this woman if I never saw a penny. I would sue her ass for wrongful death in all of these cases. And in terms of successfully completing a rehabilitation program, I haven't gotten to really researching what Pocatello Women's Prison has available to the damn Hussy. Another thing in the pre-sentence report will be a psychological evaluation. Okay, and again, all of these things that whoever was seeing her up at the Idaho Department of Health and Welfare, along with this neutral person that came in before she was committed to say, yes, she needs to be committed, all those reports will be attached. Very important information. But this investigator is going to have to do another psychological evaluation. The pre-sentence investigator may recommend a psychological evaluation, but the decision as to whether to order a psychological evaluation is to be made by the sentencing judge. Information may be included in the pre-sentence report. And again, Judge Boyce ruled a full pre-sentence investigation. So I believe they'll do another evaluation on her. The content of this pre-sentence report. The pre-sentence report may include information of a hearsay nature, y'all. Okay, so you know hearsay is not allowed in as evidence in a trial. But now hearsay nature where the pre-sentence investigator believes, okay, it's up to the pre-sentence investigator, believes that the information is reliable. Now here's where I part ways. When we're talking hearsay, Lori could tell the pre-sentence investigator, I heard here, or this is what someone said, or this or that. If that pre-sentence investigator thinks that damn Hussy's credible at all and wants it included in a pre-sentence report, they can kiss my country ass, because she ain't credible. She's going to say whatever she's going to say to make herself look like the freaking victim. The judge may consider material contained in the pre-sentence report that would have been inadmissible under the rules of evidence. While not all information in a pre-sentence report need be in the form of sworn testimony and be admissible in trial, conjecture and speculation should not be included in the pre-sentence report. Any pictures or depictions of child pornography that are included in the attachments must be placed in separate envelopes, and that doesn't apply here, y'all. But then it goes into previous charges against the defendant. Now, we know that Lori was originally, when she got arrested, she was arrested in Madison County for, remember, they dropped the child abandonment, they dropped the alteration, destruction, concealment of evidence against Chad, all these things that were dropped before they decided to go after them for first-degree murder and made it a death penalty case. So that will be included in a pre-sentence report. The sentencing judge may consider information in a pre-sentence report regarding a previous charge against the defendant that was dismissed. And then you've got Idaho Sentencing Information Database. The pre-sentence report may include a report generated from the use of a sentencing tool of the Idaho Sentencing Information Database. Additionally, report may be ordered. The sentencing judge may order an additional investigation of the case if the judge deems it necessary and use such results in considering the disposition. Now here we are on access to this pre-sentence report. The disclosure of the report and the exceptions. Full disclosure of the contents of any pre-sentence report considered by any sentencing court must be made to the defendant's counsel, and the prosecuting attorney prior to any hearing on the sentence, except as provided in this rule. So, makes perfect sense. Before July 31st, The pre-sentence report has to be given to the parties. The defendant and the defendant's attorney must be given a full opportunity, y'all, to examine the pre-sentence investigation report so that if the defendant desires, the defendant may explain and defend adverse matters in it. The defendant must be afforded a full opportunity to present favorable evidence in the defendant's behalf during the proceeding involving the determination of sentence. The trial court may, however, withhold from disclosure parts of the pre-sentence report that contains diagnostic opinions that might seriously disrupt a program of rehabilitation. In other words, Lori's got to be able to look at this pre-sentence report. If she sees things that are adverse, things that she don't like, they've got to give her enough of an opportunity to rebut it, to say whatever, her attorney will take. Hey, Lori will say, well, this section here where they say this about me, that I'm loose or whatever. She's got to come back with something. Doesn't have to be sworn to. It can be just her attorney typing up what she has said to add to it. But the judge doesn't want Lori to see anything that's diagnostic because of the rehabilitation component in it. If she sees diagnostics in it, it might mess with her rehabilitation efforts. In other words, she could see something and say, well, she has a propensity to be a freaking pathological liar or a narcissist. Well, she could start pretending that she's not. You see what I'm saying? Information that is in the court's discretion may prove harmful to an individual not a party in the proceeding. And then it talks about depictions of like child pornography, which doesn't apply. Explanation of non-disclosure, where the trial court chooses to withhold from disclosure to the defendant information in the pre-sentence report. The court must state for the record the reasons for its action, inform the defendant and defendant's attorney that information has not been disclosed, and explain the general nature of the information being withheld. Further, if requested, the defendant's attorney, if any, must be allowed to review any information in the pre-sentence report that is so withheld from disclosure so as to allow the attorney a full opportunity to explain and rebut the information contained in it. And again, it talks about it in here also that if they get this pre-sentence report and they don't feel like they've got enough time to really rebut anything, or they want to add something and they've not been given enough time, guess what happens, y'all? The sentencing hearing will be put off even further. So I don't think that's going to happen, but I'm just telling y'all. The time of disclosure. Disclosure of the information contained in the pre-sentence report under the conditions mentioned above must be made at a sufficient time prior to sentencing so as to afford a reasonable opportunity for the defendant or defendant's attorney to verify or rebut any information contained in the report. Reasonable request for a continuance of sentencing when based on lack of sufficient time to examine or offer rebuttal to information contained in the pre-sentence report may be granted by the sentencing judge. Again, y'all, this pre-sentence report's not going to have everything in it that's going to look good on Lori. And in fact, as evil as she is, there's going to be more negative shit in it than positive. And make no mistake, Archie and Thomas, they are her attorneys. And they're going to look at this and they're going to say the judge is going to look at this. He's going to make a determination. It's not the whole complete determination off a pre-sentence report, but it is weighs heavy on a judge. Would Judge Boyce, in factual just reality, know what he's going to sentence her beforehand, even before reading the pre-sentence report? Or would a pre-sentence report change his mind on what he's going to sentence her to? One can only wonder. Of course, Judge Boyce would say, I've read the pre-sentence report, taken that in consideration, along with all these other things as part of sentencing. But if he's got his mind set that her ass is going to be in prison for the rest of her life, it is what it is. The custody of the pre-sentence report In other words, who's going to hold on to this? Any pre-sentence report must be available for the purpose of assisting a sentencing court, and once prepared may be released to any district judge for that purpose. All pre-sentence reports shall be filed and kept as sealed court records except as otherwise allowed by this rule. The pre-sentence report must, however, be available to the Idaho Department of Corrections and the Idaho Commission of Pardons and Parole. Okay. Again, I don't believe that Lori will ever get paroled. I just don't believe that Judge Boyce is going to say, you got life with the possibility of parole after, 25 years or whatever. I don't believe that. I believe it'll be life without parole. Because we're talking about more than one murder here. We're talking about that damn Hussy as a serial killer. And she got away. She dodged a bullet that she shot the gun, dodged the bullet of the death penalty. So the judge better lay the hammer down on her. But again, this report, the custody of it, is given to the judge in his determination of her sentence, and it's also given to the prison that she's going to be making home sweet home for the rest of her days. And it's also, if it's relevant, a parole board, they're gonna see her pre-sentence report. No one else is gonna get to see it. It's never gonna be released. It's gonna be sealed. But I guarantee you, Kay, Larry, Summer Shiflett, Kobe, Ryan, whoever else that they deem as victims of Lori and Chad, they're going to go in a room just as they went in a room to view the photos, during the trial. I know Larry had viewed the photos. Kay said she couldn't do it. The bottom line is they're going to get to sit down in a room and go through that whole pre-sentence report. I know they're gonna have to read it because it will absolutely answer so many questions. Things that, all this time that she'd been in there for 10 months, basically we call it the spa. The bottom line is there's going to be so much in that. Every damn note that it was ever taken, down to whether or not, y'all, one of the tests that Lori had to take was to call McConkey. Remember that one? The one that got everybody's panties in a wad, where she called to find out if she could get another attorney through the Church of Jesus Christ of Latter-day Saints. All that's going to be laid bare in the pre-sentence report. Every damn day that Hussy was in there, and they're taking notes of her, what she's saying, how she's behaving. It's going to be in that pre-sentence report, along with their ideas of the variety of mental illnesses that she's going to have. The pre-sentence investigator may release information relating to the defendant's criminal history and law enforcement reports related to the offense for which the defendant is to be sentenced to persons preparing reports to assist the court in sentencing pursuant to a court order evaluation. Any person receiving this information must not release it to any other person or agency. Any violation of this rule is a contempt of court and subject to appropriate sanctions. So this pre-sentence report's got to be put on paper. It's got to be printed off. This duty will probably go through the county clerk's office. They can't let anyone know. They themselves can't talk about what they've read as they're printing it off, anything like that. They'll be put in contempt of court if they do. And availability of the pre-sentence report to what? Third parties. With the permission of the sentencing judge, the pre-sentence report may be available to persons or agencies having a legitimate professional interest in the information likely to be contained in it. If it appears that making the report available will further the plan or rehabilitation of the defendant. So, if there's a program at Pocatello Women's Prison, the program of learn to get your master's degree in biblical studies or whatever, or learn how to control your emotions or whatever the hell the program is that they've got. It may, I'm not saying it will automatically, but if asked, these people that are running the program can ask to read it to get an idea of every person that's going through these rehabilitative programs through the prison. Such persons or agencies may include a physician or a psychiatrist appointed to assist the court in sentencing, an examining facility, a correctional institute, a probation or parole department, the supervisors of a public or private rehabilitation center, availability of pre-sentence reports to problem-solving court personnel. With the permission of the sentencing judge, the pre-sentence report may be available to problem-solving court personnel for purposes of screening the defendant to determine if the defendant's suitability for admission into a problem-solving court program. And also the availability of pre-sentence reports on what, y'all? When she starts going through her state and federal appeals. Obviously, the appellate courts, first it'll be that we'll go through that. I won't go through that right now. But the bottom line is that we're never going to know. We're never going to know anything about what's in those reports. Say, for instance, Larry and Kay read the pre-sentence report, and they went out here and got on the news and started talking about what they'd learned in the pre-sentence report, they'd be put in contempt of court. And I don't know that they would do it anyway, but, it is what it is. I wonder if, will Mark Means get in touch with her? I'm sure little Lady Di, there's always a possibility that several people are going to try to get a hold of Lori when she goes to prison. I think most of the people, there'll be two categories of people that will try to write her or call her in prison. One that want to make money off this case, or two, some sick-ass person that has fallen in love with the Hussy, because you know how all that goes, y'all. I mean, I was reading somewhere where some woman was writing Alex Murdaugh in jail saying she was in love with him and that she thought he was innocent and all this bullshit. I'm sure Lori is going to get plenty of fan mail from these stupid-ass people. And I guess the third would be, I'm sure her mother, her sister, maybe others in their family might want to go and speak with her. But I'm going to tell y'all right now, Judge Boyce, I hope that he puts it in her final sentencing order that she cannot make money off this. Dodging Bullet says, hasn't Pryor had enough time to put together a defense for that chuddy chud a-hole? Well, all he said was all he needed was 60 days for the DNA expert. And as y'all recall, y'all remember back when they were arguing all this before Lori's trial, Archie said something about his investigator could not be ready to do any of this stuff, that she didn't have everything. And this was before they took the death penalty off the table. But again, this goes back to the pre-sentence investigator that will the judge appoint one, because it doesn't make it clear, or is this someone that Archie and Thomas has gotten together to do a pre-sentence report? Doesn't seem to me that would be the issue. I would think that it would have to be someone neutral, because there will also be negative stuff along with positive stuff in a pre-sentence report. Yes, I believe I just shouldn't be surprised, says Trevor Levesque. Oh, hello, Carrie Ann. Hi, Angela L. Okay, so again, in 14 days, Archie has to file this thing. He's given crappy reasons. It's not going to be overturned. And who looks at that motion for a new trial? Under Idaho law, it will be Judge Boyce. And if anyone thinks that Judge Boyce is going to look at what Archie says is the reasons that she needs a new trial, and some of them is Judge Boyce's fault, if Judge Boyce, I just don't see him saying, yeah, you're right, Archie. That's not going to go anywhere. That's a procedural thing. It had to happen. She's not going to get a new trial. But again, y'all, This new evidence stuff, this new DNA, that's what bothers me. And I think, the only thing that can be shored up about Lori staying in prison and not really getting a new trial or getting a good, valid appeal would be that Archie did say on record, my client, I told her that this information that John Pryor's over here talking about, how this DNA is last minute and it's important enough that it severed the cases, but she wants her speedy trial. There you go. Lori screwed herself. And Lori's going to have to screw herself from here on out, or find someone in women's prison that can pull that one off. So I want to close with this so that we all have a firm grip on the appeals process. That's going to happen. It's going to happen down the road, y'all. How to challenge your criminal conviction in Idaho. There's a direct appeal or action for post-conviction relief. There's two ways, y'all. There are two ways to challenge your criminal conviction in Idaho. First, you can make a direct appeal to the Idaho Supreme Court, which hasn't happened yet, y'all. The second is the action for post-conviction relief. They are made in different courts that address different issues and have different timelines of when the court has to make a decision. Now, the first one, the action for post-conviction relief, is a civil case that's developed after her criminal conviction. It's a civil case. It's almost like her attorneys are going to sue, right? They're going to sue Idaho in a civil case in which you sue the state of Idaho on the grounds that Lori's conviction was obtained in violation of Idaho law or its constitution. An application for post-conviction relief is a separate civil case made in the district court, y'all, where you were convicted. An act for post-conviction relief is made under Idaho Criminal Rule 39, which provides that the action proceeds under the Idaho Rules of Civil Procedure. In other words, the case proceeds in the district court similarly to other civil actions, including the provisions for discovery. So what this is saying is one of the ways that she's going to appeal, and she is, all of them, any way that the Hussy can appeal, she's going to appeal. They're going to sue the state of Idaho, but it's going to be a civil proceeding in a district court, and they have rules for civil discovery that'll have to happen there. Issues that can be raised in an action for post-conviction relief include claims that cannot be raised on direct appeal, such as a claim of ineffective assistance of counsel. The burden of proof in an action for post-conviction relief is a preponderance of the evidence, which is the standard in a typical civil case. And y'all remember, we talked about this probably, I guess it's going on 2 years, maybe you don't remember. But you remember, well, let me just say it like this. You know how there's been other cases where they couldn't get someone indicted in a criminal case. So the family said, okay, we can't get them indicted. So we're going to take them to civil court and make them sit down for depositions. And we're going to get a conviction on them. And that will trigger what? If we get them convicted civilly, then that will bolster this idea that they should have a criminal case put against them. And in a civil case, you don't have to, there isn't a huge burden to bear in a civil case. In a criminal case, it's real hard, okay? But in a civil case, it's different. So what they're saying is that the burden of proof in an action for post-conviction relief is the preponderance of the evidence, which is the standard in a typical civil case. So it's not like going and having a whole new criminal trial. It's a lawsuit in a civil court, and it's preponderance of the evidence. Now, then you've got a direct appeal. This is the other reason that she's going to try, okay? A direct appeal is made directly. It passes the district courts, the appellate court, and goes right up to the Supreme Court, the Idaho Supreme Court. The issues that may be raised depend on the motions or objections made in the district court. Generally, if an issue was not raised first in the district court, it cannot be raised on direct appeal. And this goes to what did Archie and Thomas bring up in the trial. Do y'all remember? 404B material. Remember they kept saying, we object, we're not going to cross-examine because we don't think this stuff from Arizona should come in. They had to put that on record so that they can do what? Do a direct appeal as well. And it's not going to go anywhere, but I'm just trying to, basically let y'all know what I've learned. An appeal is initiated by filing a notice of appeal which contains a statement of issue. And the statement of issue will be, that 404B stuff should have never came in, and this is why we think it shouldn't have. Once an appeal has been filed, the district court will prepare a record and transcript of the proceedings before it. The parties have a chance to argument the record to request additional items to be sent to the Supreme Court, but the court will not consider new evidence that was not before the district court. After the record is settled, the Idaho Supreme Court will set a briefing schedule, and the appellant generally has 35 days to file the appellant's brief. Then the respondent has 28 days to file the respondent's brief, and the appellant is given the chance to file a reply brief. Now, when we think about appeals, we think, oh, Lori's going to be going, she's going to appeal, post-conviction relief appeal. She's going to do direct appeal and all this and that. But guess what? The state of Idaho's prosecuting team, they're tethered to this too. They're going to have to go through this process as well. And in Idaho law, unless there's some good reason, Archie and Thomas will have to see Lori through her appeals process. Unless it's like some major thing like illness or death or it's been ruled by a judge, yes, Archie, you and Thomas don't have to continue doing this appeal stuff. After the briefings is complete, the Idaho Supreme Court will assign the case to either the Idaho Supreme Court or the Idaho Court of Appeals. Most criminal convictions are assigned to the Idaho Court of Appeals, and the courts rarely hear oral arguments, which means the courts decide the appeal based on the parties' briefs. In other words, the state of Idaho, Rob Wood, Lindsey Blake, Archie, Thomas, they'll never go. If they go through this process, they'll never argue anything. What happens is the Supreme Court gives the briefs of both parties to the appellate court, and they go through them line by line and look at every single case law, everything that Judge Boyce did that pertains to their argument of why they are doing a direct appeal. Once the court issues an opinion, the parties can file a petition for a rehearing or petition for a review. So even after the appellate court says, well, we've heard all this, we've looked at y'all's briefs, Lori's attorneys and the state of Idaho here, and we say, nothing's wrong here. Well, guess what? Lori's attorney can say, well, we're going to file an automatic thing to y'all saying y'all need to review it again or petition for rehearing it all over again, which rehearing means they have to look over the brief again. A petition for rehearing asks the same court that issued the opinion to reconsider its decision based upon a factual or legal error. And again, this goes back to what Archie said in his motion for trial. He says the state wanted to correct a clerical error of, these little words here and these little words here, and we're saying that was a big deal. It's going to be in there. Down the road, you're going to see it. It's going to happen. A petition for review is a request for the Idaho Supreme Court to review a case issued by the Idaho Court of Appeals. If the petitions are not made or they are denied, which they can, they can ask for that review or they can ask for reconsideration, and the appellate court can say, we deny you, or say Archie and them don't do it, which I think they will. The court's opinion is final, and that appeal is exhausted. You can forget all about it. The Supreme Court will then issue a remitter, which instructs the district court to take any necessary action consistent with the opinion if there's something wrong, and the issuance of a remitter remains the appeal. Remitter means the appeal is completed and the opinion of the appellate court is final. In summarization, y'all, convictions may be appealed to higher courts, which are the Court of Appeals and the Idaho Supreme Court. So there you go. And it's going to happen because, in my view, this is my view, y'all, Judge Boyce is going to give this hussy a life sentence. He's not going to give her life with the possibility of parole. There ain't not a damn thing that damn woman can put in a pre-sentence report that has got more weight than the freaking murders of innocent children and Tammy. And make no mistake, when she takes her ass over there to Arizona and has to deal with what she did to Charles Vallow, she'll go through their damn process at some point too. But then again, she'll have to serve out her sentence in Idaho. And if the Judge Boyce, for some snowball's chance in hell, gives her life, 25 years with a possibility of parole or whatever, y'all, it's possible. Her ass will go to Arizona and that whole damn thing will start all over again. And I'm going to tell y'all this right now. Going back to this one thing about Archie's talking about it was wrong of the state to frame their case when they was put on notice, Archie and them, a year in advance, that there was at least 5 co-conspirators, Melanie Pulowski and Zulema at least, or Audrey Barterio. And, I don't see that during the trial that Archie ever brought it out and on the record during trial, objection, Your Honor, because there are 2 or more conspirators or anything like that. Remember, this goes back to what was objected to in the trial. We know 404B was objected to, so we know that's going to be revisited. Also, this DNA evidence that was turned over at the last minute. The state did it. Did the state know it wouldn't matter? Because they have to think ahead too. Could the state have said, we got to do this at the last minute because we need to take the death penalty off the table because this is going to be a lot harder for us to prove this and we'll have to go through so much more? And really, ultimately, Larry and Kay and others have stated that our victims' family members said they were okay with it not being, that Lori didn't get the death penalty. That life in prison is suitable for her. Yes, Carrie Ann, and I went over this at the beginning. The bottom line is what was talked about by the state in April of 2021, there were a few things that they wanted tested, but they didn't get them tested because Lori went incompetent. Then it was revisited again a year later, but the bottom line is there was a couple of those things that were in the trial, and then some of it was never even brought out in the trial. And I'm just curious to know, because it says hairs. It didn't say hair. It said hairs. And John Pryor definitely wouldn't have been able to have an argument, hey, we have to sever this case because this DNA evidence, this report shows that this is Lori Daybell's hair that was inside the duct tape, and this could affect my client. No, it would be beneficial. In other words, why would John Pryor have a problem with that hair on the inside of the duct tape that was brought out in Lori's trial? Why would he have a problem with that? It can't be that. So it has to be something else. And y'all, I'm just going to say this, and this is just my opinion, my feeling about it. If that DNA evidence that John Pryor says he could get tested in 60 days comes back as Chad or Alex and not Lori's, well, what does that say to Archie and Thomas? That tells them that is evidence that would have been important in our trial. That, hey, yes, it was brought out in trial that one of Lori's hairs was on there, but there's other hairs here too. And we wrote it off that Lori's hair was floating through the air or would have naturally been with JJ. These other hairs proved that it wasn't my client Lori. And so this is important DNA evidence. But, you know, all I got to say about that, and I will close with saying this. Archie made it clear on record. He made it clear. He said, my client wants a speedy trial. She got a speedy trial. Maybe he thought that this DNA evidence might be an ace in the hole down the road on an appeals issue. But the reasons that he gives for a new trial now, they're not going to float. And the only one that's going to look at those reasons of Archie's for wanting a new trial is Judge Boyce. And he's not going to agree that any of that's right. So anyway, I just wanted to get with y'all, and in summarization, post-trial, post-conviction, this still happens. This still goes on. The demon is in the corner. She's in a jail cell. And there is always going to be that worry, that fear that somehow she will get off on a technicality. But again, you got Arizona waiting, and she's not going to be released. Even if she got a new trial, she wouldn't be released. If the appeals process, she has 2 years for new evidence to happen for her to even get an appeal. So we'll just have to see what happens, y'all. July 31st will be here before we know it. And so I love you all, and I will get back with y'all. We're trying to get back into the swing of things. Had a lot going on this week. Couldn't get with y'all. We'll talk Sunday Rays, and we'll get back on track real soon. So I love all of y'all. Thank y'all all for being here. I love you. You know I do. And keep on looking.